Hello, this is Brian Ka with another video to help you pass the California baby bar and the bar exam. So we're going to do another remedies question here. This is from October 2020, and this is question 5. So as usual, let's read the call of the question. And number 1 call of the question is, what remedies can Pam reasonably obtain against Daniel? Okay, so Pam, number 1, Pam versus Daniel. Right, Pam versus Daniel. Number 2, what defenses can Daniel reasonably raise? So 2, Daniel's defenses. Now, whenever you hear um, the call of the question or read call of the question that talks about the defenses for remedies, you have to usually assume that they want you to talk about unclean hands or laches. I've seen things like statute of frauds. Um, Another one is parol evidence. I've seen estoppel. Um, I've seen acquiescence, but I think that was from one of the the best uh, bar answers that kind of went beyond. So I'm not gonna include that, but definitely I would keep that in mind. Unclean hands, latches, statute of frauds, parol evidence, and estoppel. Now let's read the facts. Daniel's house is for sale. In his living room are two valuable original paintings by artists, one of the California coastline and the other of a field of Golden State wildflowers. Daniel recently refused an offer from museum to purchase the paintings for $10,000 each. So Daniel has what? Two paintings, one, two, and museum offered them for 10,000, and he refused. Very simple. Pam went to Daniel's house hoping to buy it before she left on a business trip. As Pam and Daniel and his real estate broker Bill inspected the house, Pam noticed the paintings in the living room, commenting that they were beautiful and seemed designed to fit in the house. Pam offered 400,000 for the house. So Pam offers 400,000 for house, right? And 50,000 if the sale included the two paintings. And here we write 50 for two paintings. So that comes out to the total contract price of $450,000. Okay. So what happened? Daniel agreed and asked Bill to draft a contract for the sale of the house and the two paintings for $450,000. Bill promised to have the contract ready before Pam left town the next day. Bill drafted a written contract which Daniel signed, even though he noticed that Bill had mistakenly omitted from the sale the painting of the California coastline. Okay, so there was a written contract, written K. Daniel signed, but he noticed that Bill had mistakenly omitted from the sale the painting of the California coastline. So they're telling you that there was a mistake. Now, whether this is a mutual mistake or unilateral, it says here that Daniel signed even though he noticed that Bill had mistakenly omitted. So he knew he had sent her, right? So that leads us to conclude that we're going to have a unilateral mistake issue. Definitely not a mutual mistake. So the next paragraph says, Daniel met Pam at the train station as her train was about to depart, and Daniel gave the contract to Pam, telling her, this is what we agreed to, and I've already signed it. Pam's train started to move, so she quickly signed the contract without reading it and jumped on board the train. Okay, so they're talking about signing, and usually that has to do with the statute of frauds, and the fact that it was already signed and she quickly signed it. Maybe we have to talk about parol evidence, but definitely I would talk about unclean hands, laches for defenses, and it seems like the question is leading us to talk about statute of fraud and possibly parole evidence. And if there's time, I would talk about estoppel because there was a promise in which Pam relied on. So if I have time, I'll talk about that. So that already sets up the second question: what are Daniel's defenses? And for that, I will talk about these 5 things. Okay, so when they met, her train was about to depart. Gave the contract, already signed it. Okay. When Pam returned from her trip, she was horrified to find that the California coastline painting was not in the house. She immediately telephoned Daniel to ask about the painting, but he told her that's what the contract we signed provides, and hung up. Okay, so something didn't go right. And what was the thing that didn't go right? Um, they signed this contract for $450,000. It was a written contract in which Daniel signed and Pam signed, right? But um, paintings were not included, which was clearly bargained for. So it seems like right away um, we're going to have unilateral mistake. But if we're representing Pam, um, the first remedy that we would like to do would probably be to reform the contract or reformation, right? That's if she wants to affirm the contract. Now, if she doesn't want to affirm the contract, if she wants to back out from there, a remedy that would be useful for that would be rescission, right? So moving on, um, 6 months later, Pam moved into the house. She noticed in a local newspaper advertisement that Daniel was offering to sell the artist's painting of the California coastline to the highest bidder at an auction 2 weeks later. So that is leading us to kind of think about equitable remedies so we can stop him from selling the paintings to a random person. So when we talk about equitable remedies to stop somebody, automatically we would have to talk about like things like temporary restraining order, preliminary injunction, permanent injunction, and specific performance. So already we got number 2 outlined here. we can kind of talk about it. Um, we already have reformation, rescission as the best remedies for this situation. Then we got equitable remedies, all four of them, and because the the benefit of the bargain, she was looking for 450,000, which included the two paintings, and she did not receive it. I guess we can get into things like expectation. Um, you know, there's no consequential, maybe restitution. If she wants to affirm the contract, if there are no other recourses, right? So already, I mean, this is not an easy essay. I mean, it's easy, but there's so many parts to it. So first, we're gonna have to talk about reforming the contract. And when you try to reform the contract, I mean, there's got to be grounds for reformation, right? And no defenses. And the grounds for reformation in this case, the best one we got is unilateral mistake. And another theory that we can try is misrepresentation here, right? And unilateral is when a party obviously knew about the mistake, but that mistake was the basic assumption of both parties, which was material, right? So for unilateral, basic assumption, materiality, one side knew about. And I guess we can talk about reliance. So the painting that was supposed to be included in the deal, um, both parties, uh, that was the basic assumption of both parties when they began negotiating and they wrote a contract. Obviously, it was material because Pam probably would not have signed the contract if she knew that the paintings were not included in the contract. Now, the important thing about unilateral mistake is that one party had reason to know of the mistake. The facts told us that Daniel knew about the mistake, and he had noticed. I think the word that they used that was that he noticed that Bill had mistakenly omitted, so he had sent her, right? And because of this, Pam, who thought that $50,000 worth of two paintings were going to be included in the contract, relied on this deal, the contract. So, is there grounds for a reformation? I think so. It's a strong, pretty strong case. As for defenses, um, I guess we can here quickly talk about whether there's laches. Was there unreasonable delay which prejudices the defendant? Not really. Unclean hands. Is there anything that Pam did wrong so that the defense could argue unclean hands, that she has no right to reform the contract also because she was at fault? I don't really see that, right? There was no misrepresentation. So for reformation, we have grounds for reformation under under unilateral mistake. Another thing we could try is briefly talk about reformation under misrepresentation, and that's when the one party had center, which we can clearly prove whether there was a statement of fact, present or past fact, that was false. Um, I guess Daniel could argue there was no real statement that was made that was false. I guess Pam could counter by saying that you saying that the paintings were included in the contract and later backing out, even though you knew that itself is a good case for misrepresentation. Was there inducement? Yes. Was there reliance? Yes. Was it material? Yes. So I guess for reformation, you can also use the theory of misrepresentation because you got to have grounds for reformation, and she can use both grounds to establish that she deserves the contract to be reformed, meaning it needs to change so that it can better reflect the original intent of both parties. And the parties both intended in the beginning that these two paintings would be included for $50,000. Another thing we can do is rescission. She can rescind the contract based on misrepresentation. I would use the same elements, and rescission is, I mean, misrepresentation is a, is one of the grounds for rescission, and it would be very similar. Um, Use the same rules for misrepresentation. And I would argue that if she doesn't want to affirm the contract, then that is another way out for her to get out of this deal, which was supposed to include these two paintings. Okay. All right. So we talked about two equitable remedies: reformation, misrepresentation. Um, and since this is long, I'm just gonna go right ahead and do TRO. For that, you would argue that Pam would suffer irreparable harm. The damages are inadequate, and um, she has a very good chance of prevailing after balancing the hardships of each party, which doesn't require notice. So, TRO, I would use those rules to flush it out, plug in the facts, and probably conclude by saying that it is very likely that since these paintings are unique and that damages are legal damages or money damages are inadequate, she would suffer irreparable harm if these paintings are sold to another person. Most likely, TRO would be granted. Now, when it comes to preliminary injunction, everything is the same except for the notice part. It can't be done ex parte. It needs to be done with notice to the other parties with reasonable time, right? So I would go through the facts again, make sure that we plug in all the facts, and most likely conclude that preliminary injunction may be granted in this case. Same thing with permanent injunction. The main thing about permanent injunction is that damages here are the legal damages here are inadequate, and it would again balance the equities, the hardship of each party, and that too would probably be granted in this case, right? That should even just this should take about 15 minutes. Now, a specific performance, the elements that we have to think about are things like was there a contract? Yes, there was. Were there definite or certain terms? Obviously there was. Um, is is the legal damages inadequate? Most likely because the painting at $50,000, two of them was unique, and you have to also talk about feasibility, whether it is feasible for the court to enforce. And it's going to be argued both sides, but I want to argue that Pam has a good chance. Lastly, we would have to talk about mutuality, balancing of the hardships, and I would say, even under analysis for mutuality, balancing of hardships, Pam probably has a good, chance of prevailing on that element also. And obviously, I would use the facts to plug in the facts to talk about this further. And going back to the laches or unclean hands, that would be the five, whether there were defenses, and I don't really see that. So we already talked about reformation, misrepresentation, the four equitable remedies. And maybe I would talk about, because I don't want to run out of time, maybe like a paragraph, short paragraph, two sentences saying if she doesn't want to go through equitable remedies, she can argue for legal damages, and that would be the price that she paid minus what she received, which was 400,000. And I would argue under expectation that she needs to get 50,000 on top of the deposit, return of the deposit, which is 400,000, right? Now, if you want to argue this, you're gonna have to talk about like foreseeability, certainty. You have to talk about causation, and so forth. Whether there was mitigation, right? Um, and because this is a contractual remedy, punitive will apply. And that's a lot. If I were to actually write this, it's going to be at least like 4 or 5 pages, maybe more. So moving on to Daniel's defenses, we already talked about unclean hands. I would just, plug in the facts, write more of it, laches. I didn't really see that, but I would talk about it. Statute of frauds is definitely something I would talk about. Um, he would argue, Daniel would argue that since it exceeded $500, it needs to be in writing. But it wasn't. But Pam could argue that there are exceptions to statute of frauds, and those situations are sometimes when there's partial performance. Now, whether there was partial performance, she did pay $400,000, $450,000. So she could argue whether that could be considered partial performance, one of the exceptions to the statute of frauds. And I would argue both sides and conclude. After that, parol evidence, Daniel could argue that the contract was completely integrated, and anything that contradicts the integrated contract, shouldn't be allowed or admissible to contradict whatever was there. And Pam could argue that there was a mutual mistake. To resolve the ambiguity or mutual mistake, parol evidence could be allowed. So I think that I would argue both, and conclude that maybe Pam has a better argument. Statute of frauds, it could be a good argument, but we would have to see if partial performance or maybe unique goods in this case could apply. Now, estoppel is when there's a promise and she relied upon that promise, and he is stopped from arguing that the paintings were not included. So those were our five defenses that we could definitely write for number two. And with that, I think should be okay. I'm not looking for like a 90 essay. I think that my goal is like a 70. Just to make sure that I pass every essay that's administered. I don't think that I want to go for a 65 because I just want to be safe. I don't want to get like 1390. I want to get like at least like 1410, 1420. And for me to do that, I would most likely need a 70. And as long as I think if you plug in the facts, flush out the rules, outline it like this, and just make sure you finish number one and two, I think that would be a 70. I don't know about a 75. Maybe 65 is okay if I did well on the MBEs, but definitely I think that I could do a 70 here. And with that, I don't know if I could do more remedies questions because I have to start preparing for wills and trusts. And even though I've done like each, previous essay like 4 times, the thing with these questions is that when you're bombarded with so much information all the time, you tend to forget what you just studied like a couple of weeks ago. But if you read it again, it comes back. So with that, I hope that this, if you're struggling with this particular question, that what I said here helped you. And again, I appreciate you and thank you for watching another video. And I'll talk to you guys soon.